And turning now to new developments in the investigation into former President Donald Trump's handling of classified documents. NBC News has exclusively learned that the grand jury hearing evidence about this case is expected to meet again this week after a hiatus. Now, we don't know whether prosecutors are prepared to seek an indictment at this point, but by all appearances, it appears that special counsel Jack Smith's investigation is nearing its end. If he is indicted, Trump would be the first president ever to be charged with a federal crime. Joining us now is NBC News senior legal correspondent Laura Jarrett, MSNBC legal analysts Danny Savalos and Barbara McQuaid, who's also a former U.S. attorney in Michigan. Thank you all for being here. Laura, let me start with you because this is your excellent reporting. Walk us through what more you know.
It's really a story of timing. After weeks of lots of frenzied activity at the courthouse there in Washington, D.C., the grand jury went dark. And the question is why, starting in around early May. Now, there are lots of reasons that prosecutors might be taking a break to reevaluate their evidence. Maybe they heard something, someone said something interesting, they want to bring someone back. We just don't know. We're not prepared to yet report about what exactly is going on there, but the timing is worth noting. And the fact that they are now coming back this week after a lull is noteworthy.
What's your interpretation of this return, Danny? The fact that the grand jury is coming back after the break, is it an indication of a conclusion or a potential continuation of the investigation?
Here's the challenge with grand juries and scheduling. Because everything is kept so secret, it could be true that the grand jury is wrapping up. They could be convening to begin drafting a report that may charge nobody. It may just be a report explaining why nobody was charged. But then there's always the possibility it could be something totally mundane, like a scheduling issue. Maybe one grand jury expires, the other one comes in. There are many reasons why a grand jury may adjourn and then reconvene later on. So we have to keep that possibility open. Is it possible the walls are closing in or the end is nigh? Maybe, but not based on, there's nothing concrete about that right now. We have to leave open the possibility that this could just be business as usual and that the end is not nigh, that something else is coming, maybe not too soon.
Barbara, we have talked a lot about that recording of Trump talking about a document he supposedly took from the White House that has to do with Iran. Well, now the New York Times reports that lawyers have been unable to find that document. So if it is in fact missing, what are the legal implications here?
Well, I think there are two possibilities, Anna. It could be that this is a very sensitive document and it's gone missing because Trump has mishandled it, destroyed it, hidden it, concealed it, sold it, given it away. If so, that's a very serious national security concern. If it is what it purports to be, talking about attack plans for Iran, that's a huge issue. It could also be that there was no such document. And in that case, I think it's largely irrelevant because one of the important aspects of that call is that in it, Donald Trump admits that he understands the classification rules. And to me, that's the larger significance of this recording. He has maintained that he could declassify documents just by thinking about it without communicating it to anyone. And I think most of us realize that's nonsense. But because the law requires that you prove that he violated it willfully, that is, that he knew what he was doing was illegal, it's important to show that he knew he could not declassify documents just by thinking about it. And so this recording would seem to completely rebut that defense that he has put forward to date.
But if the recording suggests one thing and then there's no physical evidence of what was discussed on that recording, if they haven't been able to locate such a document, then could it be hard to prove its existence? And could that actually benefit Trump in some way?
Only if the government tries to charge him with mishandling that particular document. And my guess is if they aren't able to find it or find that it ever existed, they may not do that. So that piece of it might be something that is not of legal significance that can be used in the case against him. But that admission of his understanding of the classification system, I think, is very valuable evidence.
And real quick, Barbara, I just want to get your thoughts, too, on the grand jury reconvening and what it could or couldn't mean.
Well, all the things that Laura and Danny said are absolutely true. There may be any reason they are. But here's one possible theory, just a theory. They last met May 5th, and now they've had this period of quiet, and now they're coming back. It could be, I would imagine, that after the grand jury has done all its work, heard all of its witnesses and testimony, Jack Smith and his team would need time to put together a prosecution memo, submit that to Merrick Garland, and get his approval. Remember, he can reject a recommendation by the special counsel if he finds that it is unwarranted by law or inappropriate under the Justice Department policies. So I imagine that process would have taken a few weeks. It could be that he has now been given the green light and he's ready to go back to present an indictment to the grand jury.
Guys, I want to play something that Trump's former lawyer said on Meet the Press yesterday. Let's listen.
To me, even if he did a lot of the things that they're saying that he did, prosecuting him, there are the same reasons why you wouldn't want to prosecute him as to why back in 2016 I was of the opinion that Hillary Clinton shouldn't be prosecuted, because there are all of these other problems.
Laura, obviously, this isn't apples to apples comparison here. What are the differences?
The problem with that argument is that the facts are so different. We're talking about a much larger set of classified materials in the case of Trump, and it really is going to come down to an evaluation of intent. He's sort of presupposing in that answer that his former client didn't have the requisite intent, that he didn't willfully retain the documents. The worst fact for him on that score is that he didn't give them back when he was asked to. He got a request the nice way, and then he got a subpoena, and then they had to actually get a search warrant. And so that's completely different than the case of Biden, Pence, and Clinton.
Danny, what are you watching for this week?
A lot of what is happening over at the grand jury, which is we're not going to know what's going on. But going back to what Laura said, I think there are similar. If we're going to respond to what Tim Parlatore said in that interview, then we have to acknowledge the similarities that they are, and that will make the differences stand out in even more stark contrast. And by that, I mean, is there a significance that this is a presidential candidate going into an election? Yes. Does this investigation involve documents? Yes. But beyond that, I think Laura is spot on. It is the knowledge and the intent and all the evidence we have of the surrounding circumstances. You know, it's easy enough to prove that there were documents, they were in the White House, then they were in Mar-a-Lago. That is the actus reus. That is the physical evidence. The challenge for prosecutors is and will always be proving the mental element, the intent. They didn't really have it with Hillary Clinton. Here, Donald Trump is helping out prosecutors by going on the air and saying things in his Trumpian fashion that he doesn't realize are getting him in trouble. And every defense attorney in the world since the dawn of civilization can tell you that every client who thinks he can talk his way out of trouble often talks his way right back into it or into deeper trouble.